That's what you can do. Another within that waiver, if they're not going to sign a full waiver, the other thing that they can consent to do is just provide the investment statement or an in-force ledger in the case of a policy as substitute for the accounting. So they can agree to let you just serve that on them, and that'll serve as the accounting. So there is an out, and this is clearly the better way of doing it, so if the desire is not to have to prepare an accounting. All right. I went through all of this. And again, why would the trustee want to do this is because it limits the ability for the beneficiaries to sue them later on. If you serve them with the accounting or any of these substitutes, whether it be the waiver or whether it be the investment statement, there's a 6-month statute of limitations. If they don't challenge if they don't challenge it within 6 months, they're barred from ever coming back against the trustee for any of those actions that occurred during that time period. Okay. All right, so that's scared enough of you. If you're acting as a trustee, one of two things are going to happen. You're going to go back to the office and send waivers to everybody that you know, or you're going to resign, one of those two. And I will tell you, either one of them is the right course of action. Brooke? No.
Or this is grandfathered?
This is grandfathered. This applies to every trust that's out there. Every single trust that's out there. So any irrevocable trust you have, you're required to do this. Okay. Any other questions on the trust portion of it? All right. Or they just don't want their children to get any of them anymore. They decided they like their grandchildren more than their children. It happens all the time. All right? I'm going to talk about some issues with irrevocable trust that can be done either while you're drafting the irrevocable trust, or if you're in a bad spot, we can get you out of it. Okay? First, let's talk about generation skipping. I'm confounded when I see trusts that own permanent life insurance that get paid out to the kids outright. The opportunity and the leverage that's being missed there is tremendous. Let's take this typical situation. Let's say there's a $5 million insurance policy. Client is paying $100,000 a year for 20 years. Okay? So they've put in $2 million into the policy, and that's even a bad example because that's more premium than they probably pay. They put in $2 million into the policy, and the death benefit is $5 million. Okay. Trust was a great idea because we avoided taxation in the estate of the parents. Now, mom and dad die, and the money gets distributed to the two kids. $2.5 million, $2.5 million. And now, kid number's one spouse, the day after they receive money, decide, it's not such a good marriage anymore, I'm out of here. The money's in play. Kid number one, after he inherits this money, goes out and gets into an automobile accident and is now being sued by all 37 kids on the bus. That money is in play. Kid number one was a very astute real estate investor while the market was going up. She's not such an astute real estate investor while the market is going down and is now being sued by banks and other deals that come in. The money is in play. What's the better way of doing this? What's the better way of doing it? It's so simple. Instead of the money going outright to the kids, the money goes in trust for each kid. As a matter of fact, each kid can even be the trustee of their own trust. When mom and dad die, kid number one gets a $2.5 million trust, kid number two gets a $2.5 million trust. They're each their own trustee. During their lifetime, we have what we call a distribution trustee set up with them. The sole purpose of that distribution trustee is to consent to distributions that they make to themselves. And we give them the right to remove that distribution trustee if they don't end up liking what their decisions are. But the money goes in trust. It's protected from divorce. It's protected from liabilities, and for 360 years, as long as that money stays in the trust, it won't be taxed again. So it'll go from generation to generation to generation with no tax. And we haven't lost anything. It didn't cost the client a nickel more to do this planning, and they leveraged part of their generation skipping exemption. They've used up $2 million. Right now, a married couple would have $4 million combined of generation skipping exemption. We've used $2 million of it to transfer $5 million. I think that's a pretty good use of the GST exemption, and we've set up trusts that go on without tax for 360 years. In my opinion, there's no excuse ever for not setting it up in this fashion. If you're involving term policies, it's a different analysis. You may or may not, depending on what the use of the term is for. But if you're setting up permanent life insurance, there's no reason why the trust should not be generation skipping. All right, next issue. Trust protector. Remember that example I gave before about mom and dad changing their mind about not liking the way it's set up? Well, every irrevocable trust that we draft contains something called a trust protector. A trust protector is someone that has certain independent powers within the trust. They can change the trustee. They can change the manner and distribution to a pool of beneficiaries that the client suggests. They can't add anybody to that pool of beneficiaries, but they can rearrange the manner and the percentages by which those beneficiaries get the money.
Within certain specified limits?
The client could either specify it or not specify it. Generally what happens is that pool would be the kids, the grandkids, or any descendants, the kids and their descendants, and sometimes the clients will include spouses, sometimes the clients won't include spouses. What we've been doing more and more is we'll include the spouses if they've been married for 25 years or longer. So if it's a marriage of 25 years, then they're within that pool. If it's less than 25 years, it's not in the pool. Okay? We can change administrative provisions of the trust if the laws have changed or if the manner in which it's prudent to handle an irrevocable trust has changed.